Whether you are a tenant or a landlord, if you understand the Model Tenancy Act, half the disputes will end before they even begin. It is 10:30 at night. Loud voices are coming from outside a flat. Inside, the landlord is saying that the rent did not come on time, so now vacate the house. On the other side, the tenant is saying that the rent was suddenly increased, the security was also deducted, and now there is talk of eviction without notice. The neighbors shut their doors, messages begin circulating on WhatsApp, and the same old question stands in front of everyone once again. Who is actually right? Millions of rental relationships in India have continued in this same fog, where there is a lot of trust, but very little paperwork, where there are many conversations, but the terms are not clear. And as long as everything keeps running smoothly, no problem is visible. But the moment rent gets delayed, there is an argument over the security deposit. Or the situation reaches the point of vacating the house, that same informal arrangement suddenly turns into a legal battle. This is where the story begins. Of a law that wants to bring the relationship between landlord and tenant out of the world of verbal understanding and into the world of written rules. The issue of tenancy in India has always been a little complicated because subjects like land reforms and rent control fall within the domain of the states. That is why, in practice, the same rental law does not apply uniformly across the whole country. In June 2021, the Union Cabinet approved the Model Tenancy Act, but Parliament did not directly impose it across the whole country. It was circulated to states and union territories as a model framework for adoption. According to PRS's 2026 analysis, by December 2025, Andhra Pradesh, Tamil Nadu, Uttar Pradesh, Uttarakhand, Assam and Arunachal Pradesh had enacted their rental laws in line with this model. This means one thing very clearly. People who assume that the Model Tenancy Act is now automatically applicable all over India know only half the truth. The real position is that wherever your property dispute exists, it is necessary to see the actual law of that state. Still, why is the Model Tenancy Act so important? Because it shows us a new legal direction. The basic objective of this framework is to make renting more formal, more transparent, and more balanced. According to the PRS summary and the draft text of the Ministry of Housing and Urban Affairs, the purpose of this law is to protect the interests of both landlord and tenant, regulate renting, and provide a speedy adjudication mechanism for disputes. In other words, this law was not made only to protect the tenant or only to empower the landlord. The idea is that the rights and obligations of both sides should be clear in advance so that confusion and litigation later are reduced. That is its biggest strength. The first and perhaps biggest feature of this new framework is that tenancy should ideally no longer remain just a spoken arrangement. The text of the Model Act clearly says that after the Act comes into force, no premises should be rented out or taken on rent without a written agreement, and the details of that agreement must be given to the rent authority within the prescribed time. According to the Act, the landlord and tenant must jointly inform the rent authority within 2 months from the date of the tenancy agreement. If they do not inform jointly, then both may separately have to provide this information. This means that the old thinking, "We made an 11-month paper, that's enough," is now being firmly challenged. The emphasis now is that the contract should be written, the terms should be recorded, and there should be a traceable record of it with the authority. This is exactly where most disputes used to be born. Many times, there was an agreement between landlord and tenant, but things like rent revision, notice period, repairs, entry rights, subletting, lock-in, deposit refund, and vacancy terms were not written clearly in it. The Model Act tries to reduce this ambiguity. According to the PRS summary, the written agreement should specify things such as rent, tenancy period, rent revision terms, security deposit, reasons for the landlord's entry, and maintenance responsibilities. Think about it. If right at the beginning, it is written when the rent will increase, who will carry out which repair, under what situations the security deposit will be deducted, and when the tenancy will be considered to have ended, then later the discussion will be based on facts instead of emotional arguments. That is the real power of formalization. Now let us talk about the issue on which the most tension happens: security deposit. Even today, in many places in large cities, complaints are heard about asking for deposits of 6 months, 8 months, and even 10 months. The Model Tenancy Act proposes a clear cap on this. According to PRS and the ministry's text, for residential premises, the security deposit should not be more than 2 months' rent, and for non-residential premises, this cap is up to 6 months' rent. Not only this, the Act also says that when vacant possession is handed back, the landlord will refund the deposit after deducting the liabilities of the tenant. This provision is important for the tenant because it limits arbitrary demands, and it is important for the landlord because it does not eliminate the deposit completely, but keeps it within a reasonable limit. But this deposit rule does not mean that everything becomes easy for the tenant and everything becomes difficult for the landlord. The law tries to create balance. If the tenant damages the property, makes unauthorized structures, or does not fulfill repair obligations, the Model Act gives the landlord room to recover some expenses from the security deposit. According to the Act, if the tenant does not fulfill repair responsibilities, the landlord can get the repairs done and adjust the expense from the deposit. And if the expense is more than the deposit, the excess cost can be recovered from the tenant. On the other hand, if the landlord does not fulfill necessary repair responsibilities, the tenant can get the repairs done and adjust that expense from the later rent. Although in 1 month the deduction cannot exceed 50% of the agreed rent. That means the law is not one-sided, it is reciprocal. The maintenance issue here is very interesting because a large part of everyday rental disputes happens over exactly this. Who has to replace the fan? Who will fix seepage, flush, tap, switchboard, painting, structural crack, pipe leakage, common facilities? Often there is no written clarity on all these. The Model Act says that the landlord and tenant will try to keep the premises in the same condition as at the start of the tenancy, except for normal wear and tear, and the repair maintenance responsibilities will be decided according to the second schedule or the tenancy agreement. The practical meaning of this is that if the agreement is drafted intelligently, then the dispute of was this your responsibility or mine can be resolved to a great extent in advance. The law provides the path, but wisdom comes from putting detail into the written agreement. Getting rent on time is the biggest concern for the landlord, and getting a rent receipt is the biggest protection for the tenant. The text of the Model Act says that the tenant will pay rent and other charges within the agreed period, and the landlord or his property manager will give a receipt. If payment is made through electronic mode, then the bank acknowledgement will be considered proof. This provision may look small, but its importance is very large. Because in India, many disputes stand on exactly this issue. The rent was paid versus we never received it. Digital proof, signed receipt, and banking trail become protection for both sides. The less the informal cash culture remains here, the fewer legal troubles there will be later. There is another very practical problem. What if the landlord refuses to accept the rent at all? Many times, in order to escalate the dispute, the rent is deliberately not accepted so that later the tenant can be accused of default. The Model Act provides a path even for this situation. According to it, if the landlord refuses to accept rent or charges or refuses to give a receipt, the tenant may first send the rent through postal money order or the prescribed method. If the landlord does not accept it for 2 consecutive months, then the tenant may deposit the rent with the rent authority. This clause is important because it gives the tenant a defensive legal shield. That means if the tenant genuinely wants to pay rent, they do not have to remain helpless and merely face accusations. Now let us come to the part where the biggest disputes happen: rent increase and eviction. The Model Tenancy Act also tries to make rent revision agreement based. According to PRS and the draft text, rent revision will take place according to the terms of the tenancy agreement between the landlord and the tenant. If there is a dispute regarding revision, then the rent authority may determine the revised rent. This means that the landlord cannot arbitrarily increase the rent any month at all if the agreement does not give such a power or process. This gives stability to the tenant. But at the same time, it does not completely remove the landlord's power. He can increase it according to the agreement. That means the message of the system is clear. Only that increase which happens through a written rule will stand. That which happens suddenly will lead to dispute. In matters of eviction too, this law tries to bring clarity. According to PRS's legislative brief, a tenant may face eviction. If they refuse to pay the agreed rent, do not pay rent for 2 months or more continuously, extend possession over the whole or part without the landlord's written consent, misuse the premises, or make structural changes. That means vacate the house should no longer be just a matter of anger or personal resentment. There should be specified grounds for it. On the other side, the landlord should also not be left in indefinite helplessness. If the tenant is continuously defaulting, misusing the premises, or making unauthorized changes, the law gives the landlord a structured way to recover possession. And this is exactly the part where many people remain confused because of half information. Some tenants believe that once they are inside, they practically cannot be removed. Some landlords think that since the property is theirs, they can call the police any day and throw the tenant out. Both assumptions can be wrong. The model framework says that recovery of possession and the eviction process will go through a formal mechanism. That is why a structure of rent authority, rent court, and rent tribunal has been proposed. According to PRS, under the Model Act, the jurisdiction of civil courts is barred in certain tenancy matters, and tenancy-related disputes can be taken into this specialist framework. That means the idea is faster, more focused dispute resolution, not endless civil litigation over every small tenancy quarrel. If the tenant does not vacate the premises even after the tenancy ends, the Model Act gives the landlord protection in the form of enhanced compensation. According to the Act, if the tenant does not vacate the premises after expiry or lawful termination of the tenancy, then for the first 2 months they may have to pay twice the monthly rent, and after that 4 times the monthly rent for the continuing period of possession. This provision is much discussed because it discourages unlawful holdover, but it is also necessary to understand its correct meaning. This is not an instant street-level recovery rule. It is a framework of statutory consequence, which must be read along with the applicable state law and adjudicatory process. Still, it gives the landlord a clear bargaining and legal protection, which was very weak in the old informal system. The law also contains some very important protections for the tenant, which are talked about less. For example, essential services. According to the Model Act, if the landlord wrongfully cuts off essential supplies such as water, electricity, piped cooking gas, passage lights, lifts, parking, sanitary services, or communication links, the tenant can approach the rent authority. The rent authority may conduct an inquiry, pass an interim order for restoration, award compensation, and may also impose a penalty on the tenant in case of a frivolous complaint. This balance shows that the law wants to keep both sides disciplined. The tenant has protection, but no freedom to misuse it. The landlord has authority, but no freedom to harass. Another big truth of this whole story is that the Model Tenancy Act does not apply to every property. According to the Act, certain premises, such as government-owned premises, premises given to employees under service contracts, some religious or charitable institutions, Waqf-registered premises, and categories exempted in public interest, may remain outside the Act unless the parties specifically agree otherwise were allowed. So, assuming that every rental relationship will automatically be governed by this model can be a practical mistake. That is why in any dispute the first thing to be checked is what category the property falls under, what the state law says, and in what framework the agreement has actually been made. Now the most important question, will this law really end all disputes? No, a law by itself does not end disputes. It gives a clear path to understand and resolve them. The real difference will come when both landlord and tenant take documentation seriously from the very beginning. There should be a written agreement, identity and address records, rent transfer through a banking channel, deposit acknowledgement, inventory list, repair responsibilities written down, entry rights clearly stated, police verification and society rules followed, and renewal and exit processes written in advance. The model law pushes this entire formal culture. That means the solution lies not only in the book of the act but also in the quality of the agreement. So if you are a tenant, do not look only at how much the rent is, also look at what exactly is written in the agreement. And if you are a landlord, do not look only at the tenant's profile, also look at how strong the paperwork is. India's rental economy is now moving from trust to contract. This change may feel uncomfortable, but in the long term, it will save both sides. Because when the rules are clear, suspicion reduces. When rights are written, emotional blackmail reduces. And when there is a structured forum for dispute, the frustration that the law can do nothing also reduces. That is exactly why this topic is so important. Giving or taking a house on rent is not just a monthly transaction. It is a relationship of property, privacy, money, dignity, and legal rights. And the sooner people understand this relationship formally, the less it will turn into disputes. In the end, understand this clearly. The Model Tenancy Act 2021 is not a magic wand, but it is certainly a very strong signal that India's rental system is moving from the era of somehow it is running to the era of written, traceable, and accountable. Where this law or a corresponding state law is in force, the rights and obligations of both landlord and tenant may be clearer than before. And where it is not yet in force, even there, its philosophy can work like a guideline. Keep the agreement written, keep the terms clear, keep the payments documented, and when a dispute comes, move with evidence, not emotion. The truth is that most rental disputes arise less from the lack of law and more from the lack of clarity. Once clarity comes, many fights can end even before they reach court.
If our video has taught you something new, do not forget to like and share this video so that this information can reach others as well. Your likes and shares are a source of inspiration for us. If you have any questions or suggestions, please let us know in the comments. It will be our honor to answer your questions and listen to suggestions. And yes, if you like our content, subscribe to the channel and press the bell icon so that you stay connected with every new story. Thank you. GRT Business YouTube channel sources, news from various news agencies, opinion polls and other public sources. We try to ensure that every report and summary is accurate and verified, but we are not responsible for any dispute or error. Our aim is only to provide you with accurate information.